Okay, let's switch gears to power of attorney. And I bring this up because this is a question that somebody brought to my attention, and I didn't know the answer. And I know it varies, but when we're talking of power of attorneys and banks, and particularly power of attorneys and how they work with trust. So let's say you have a not to go down the all the different scenarios, but let's say you have somebody with a simple trust and the bank account, let's say it's a savings account, is titled to the trust. It's revocable, right? And then the daughter or son has power of attorney for her parents, who are the owner of this trust that own the bank account. Can they use their power of attorney powers to access, like, to work on behalf of like the trust, or is there like a fine line where I don't know, it has to be separated or something?
Yeah, so I can imagine an argument that someone serving as an agent under a power of attorney would act on behalf of the individual parent, let's just, on
Uh,
behalf of mom, and mom as the settlor of the trust, uh, they're going through that door, but
mm.
really, and again, sometimes it's, oh, well, my neighbor did that and that it worked for them.
Right.
That's exactly what they did. Well, okay, well, technically, if it's a trust account, like the owner of the account is the trust controls that. So you have to look at the trust. And if the trust says mom is the trustee, so long as mom has capacity, the
Mm.
trust will even say, what does it mean for mom to have capacity? Do we need a doctor's letter that says she no longer can make financial decisions for herself? Sometimes it's once all the kids or spouse and kids or just spouse, the trust can sometimes say who gets to decide when, for the purposes of the trust,
Mm.
mom no longer has capacity. Um, if that's the case, then mom is no longer trustee. And so the successor trustee is the person who has access to trust accounts. So mom, as the settlor of the trust, the person who created the trust, is not accessing her bank account that's in the trust as that settlor. She's accessing the account as the trustee.
Mm.
So only the successor trustee should be the one who has access to that trust account. It can get tricky.
Sure.
I've seen the argument in an instance from the other trying to get in through the settlor door, but no, it should be, if it's a trust bank account, the trustee has access. If the first line trustee, is incapacitated, then we go to the next one.
Mm. Yeah, and in my experience too is, I mean, the banks have to follow the law. You can't make your own rules, but each bank can have their own policies on and how they go about handling these situations where, like you said, somebody might say, "Well, my friend said that they just did this." And it's
Yeah.
like, well, maybe that was a different bank and this bank has different policies. They're
Mhm.
still abiding by the law, but they require, I don't know, different documentation or different something.
Yeah, and my favorite thing when people tell me, "Oh, my cousin this, my neighbor this," I'm like, "You do not know all the facts of that
Right,
situation.
right.
You know what they told you. They may not know all the facts. So every situation is unique. Every bank is unique. Every financial institution is unique. There's a law. The documents themselves are unique. Like I said,
Right.
where the trust usually says, what does it mean who's the backup? What does it mean to be incapacitated? Who gets to decide that? Maybe all of that was different for your neighbor's mom, versus
Mm.
you.
And that kind of brought up something that popped in my head is I don't know how common this is, or maybe I'm the only one that hears these stories, but like a real conniving, deceitful child who finds a way to manipulate and change the trust and take all the assets. But there's like safeguards in place to prevent a lot of that on like your end, right?
Yeah, so I mean, it comes up where, yeah, the plan was in place forever, everything was fine, and then the rogue child comes back,
Hmm.
from somewhere, or comes in, shows up, comes out of the woodwork, and weasels their way in and takes
Hmm.
mom to a different attorney than the one she's been
Right,
using for
right.
30 years. And then, a change is made and now everything's going to that child, or that child's in charge, where they weren't before.
Mhm.
So it happens. The other attorney, our job as attorneys is to make sure that we have the meeting with the client, the person setting up the document, that we're comfortable that they have. It's called testamentary capacity, which just
Mhm.
means that they have the mental capacity required to create these types of documents.
Mhm.
So, and that, because again, sorry, another tangent where, the question is, my mom forgets stuff sometimes, but she knows who
Mhm.
she can make this plan, but
Mhm.
I'm worried she's starting to get forgetful. So that's why I want her to do this planning, so you can have the ability to create these documents where in another scenario, maybe someone would say, yeah, no, you don't have the
Mhm.
capacity to do XYZ. That's a little in the weeds,
Yeah.
but back to the safeguards and all that in place. Yes, the attorneys have it. Sometimes what they'll do is it's not going to be an amendment or a change made by an attorney. The kid gets the piece of paper and, writes it out or tells mom what to
Mhm.
write, and then they sign it. And sometimes, so it's not necessarily even just incapacity where she didn't know what she was doing. Someone told her to. She wrote A. Sometimes it's fear of abandonment. It's this
Mhm.
kid is here taking care of me. All my other kids aren't here. They're not here to take care of me.
Right.
If I don't do what this person wants, are they going to abandon me? Am I going to end up in a home? Am I going to end up out on the street? What do I do? Um, so they can know what's going on and they're doing it under duress, I guess is how you would
Right.
say that. So there's a lot of different safeguards in place from the legal perspective, but not everything that the child does might go through an attorney. That being said, is you can write on a piece of paper, I want my child to be in charge, signed here. You can go before a notary, who's
Right.
not always
Right.
an attorney, sign it, and the notary's job is just to say, who's this person? They say that this is what they want, and I'm just here to say, yep, they were here and they signed it.
Mhm.
Uh, and then that can get presented, and the validity of that then gets challenged.
Right.
But is the damage already done because it's not something happening after the person dies? It's a power of attorney or something that, because you can pull, power of attorney forms. The law in Hawaii that about powers of attorney gives you a sample form in
Mhm.
the law. And so, that just has to be notarized. And so
Mhm.
people can sometimes do that. They go in, they access the accounts that are not in the trust. They change beneficiaries on retirement accounts or things like that,
Mhm.
using that power of attorney. So it happens, and it's not always, can't always undo the damage. But if there was duress, if there was fraud, if there was anything like that, there are safeguards in place to try to remedy as much as you can. But
Mhm.
unfortunately, it happens,
Yeah.
and some things are irreversible. I always tell people just keep track of your elders, just keep
Right.
track,
Right.
check in.
Yeah. For sure.
Not because, and not only just because you want to avoid that
Right. Right. Right.
situation, you
Right.
check in on them
Yes.
anyway.
Because you love them. Right.
Yes, yes, yes.
Yeah.
The opinions and statements presented on this show are for general information only and are not intended to provide specific advice or recommendations. Never make any investment or financial decisions based on information offered on this show without first consulting your financial, legal, or tax advisor. All economic and performance information mentioned on the show is historical in nature and is not indicative of any future results. All indices mentioned on this show are unmanaged and cannot be invested in directly. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. Lastly, all opinions expressed by Jason Cutitta and any guests on the show are solely their own opinions and do not reflect the opinions of or are endorsed by ToBA Financial. For Jason Cutitta, investment advisory services are offered through ToBA Financial LLC, a registered investment advisor offering advisory services in the state of Hawaii and in other jurisdictions where exempt from registration.